Hi folks, my name is Dan Richardson and I've been an immigration attorney for over 8 years. In this little video I'm going to talk to you about how crimes can impact immigration status. In particular, we're talking about the impact of crimes upon green card holders and illegal persons present in the United States. There are certain felonies which are under the federal code listed as what are called aggravated felonies. Sorry about that. And aggravated felonies require special court action in order to set aside some of those impacts in order to still be able to retain your green card. If you're not able to do that special court action, then you will most likely be deported and you will forfeit your green card. There are also crimes involving moral turpitude, and we sometimes refer to those as CIMT. And crimes involving moral turpitude, which are things that have bad intent in them, for example, robbery or shoplifting, things like that. When there's a crime involving moral turpitude, the person may be able to retain their green card in immigration court, but it is also possible they will lose the green card. The final point that I want to make is what we call post-conviction relief. Earlier, when I was talking about aggravated felonies and special court action, this is what I'm referring to. It is possible that by going back to state court and altering the actual plea or the characteristics of the charge, it is possible that you can still retain your immigration status. It's important to recognize that there are several areas of the Immigration Service now that they've been reorganized, or when I say now, it was several years ago. The one that does the enforcement here in immigration court is called USICE, or U.S. Immigration and Customs Enforcement. And these folks have the attorneys on staff who initiate and prosecute the immigration court proceedings. Proceedings begin with the issuance by U.S. ICE of a notice to appear, also referred to as an NTA. The NTA is due to allegations of unlawful conduct in violation of the immigration statutes, and it will set forth both the factual allegations as well as the statute that is believed to be, or is alleged to be, violated. The respondent, which is the defendant in the immigration court, the respondent is required to appear in the immigration court, also known as the EOIR, to respond to the charges with whatever defense they're going to come up with. And obviously they want an attorney to help them do that. So what are the defenses to charges? The primary defense in immigration court is cancellation of removal. And this is now the term that we use in immigration court. It used to be deportation, but we now say we're going to cancel a removal, or in other words, the person can stay in the United States. There are two different standards for cancellation of removal. One is for lawful permanent residents, and the other is for non-resident aliens. Each one has a list of different requirements, and I'm trying to keep these videos short, so I'm not going to go into it. However, I have articles on the website, elsewhere in my website, that explain it in detail. So if you're affected in that way, you will want to refer to one of my articles on that. The other defense to a charge can be adjustment of status. And adjustment of status I refer to in a separate video and separate content on the website. I'm not going to go into those details here either. Voluntary departure is the final major defense to charges in the immigration court. Voluntary departure, in essence, says that you're going to pay your own cost of going back to your home country, and if the immigration judge allows it, you can go back without the penalty of it showing as a deportation or a removal on your record. You still may have to deal with the bar to reentry, but at least it doesn't count as a deportation. So what is the actual process for deportation and or removal? And I'll try to be consistent and just refer to it as removal. The notice to appear is issued, and I already discussed that U.S. ICE issues that and what is contained on the notice to appear. The Executive Office for Immigration Review also known as the immigration court, is where the matter will be heard. There are immigration judges who act just like superior court judges in the state court, and they hear only immigration issues and deal only with immigration issues. The first step in the immigration court is the master calendar hearing, oftentimes referred to as a master hearing. At this hearing, the individual will enter their plea in terms of what defense they're pleading, and then if they have the basic facts to on the surface be entitled to that defense, the immigration judge will order them to prepare their defense and possibly do some additional court filings to support the defense, and will schedule at the master hearing the individual, and it's sometimes called the merits hearing, at which point in time the defense will be presented and the individual will receive a ruling from the immigration judge as to whether the defense was adequate, in which case the charge will be denied and they will be granted a green card or whatever status they're seeking in the immigration court. And if they are denied that relief, in other words, they lose the case, they can appeal that to the first level of appeal for an immigration case in immigration court, and that's the Board of Immigration Appeals, also referred to as the BIA. The Board of Immigration Appeals will issue a ruling on that, and if they lose again and want to appeal that further, they can appeal it to